All right, welcome to this explainer designed specifically for you law students out there. Today we're going to navigate what is honestly one of the most dramatic and I'd say fascinating paradigm shifts in the entire legal landscape. We are talking about the evolution of custom in Hindu law. We're going to trace its epic journey from being this ancient, undisputed supreme authority all the way down to its modern subjugation under strict statutory frameworks. So, if you're trying to figure out exactly how traditional practices survive in today's courtrooms, you are absolutely in the right place. Let's dive right in. Here's our quick roadmap for this session. We'll start with the ancient paradigm where custom was literally king, then categorize how it actually manifests. After that, we'll run through the modern judicial gauntlet, those validity tests you absolutely need to know, and finish up by looking at the modern legal hierarchy. Okay, kicking things off with our first section, the ancient paradigm, or the golden age of custom. I want you to completely reset how you think about law for a second here. There is a massive paradigm shift you need to memorize. Think about the stark contrast between the ancient view, where custom wasn't just some secondary backup plan, it was so incredibly powerful that it could literally override sacred texts. Contrast that with our modern reality, where a custom has to survive a brutal, highly restrictive validity test just to even be recognized in a courtroom. So how exactly did we get from point A to point B? Well, to understand the sheer historical weight of this, let's look at the ancient jurist Narada. Now, this is a crucial quote. He explicitly stated that custom was so powerful it could override the sacred law itself. The Smritis, the ancient sacred texts, actually mandated the supremacy of custom. The written word was completely secondary to the established traditions of the people.
And it wasn't just Nara. Another major ancient jurist, Brihaspati, reinforced this exact same principle. He wrote that custom can outweigh the written text of law. In the ancient world, law wasn't something handed down by some distant parliament, right? It was a living, breathing thing. This living law of the people carried far more weight than any rigid written code ever could.
In fact, the very vocabulary of this ancient legal system perfectly reflects the supremacy. You see concepts like akara, sadachara, and shishtachara, which essentially translate to the practices of good men. Notice the reference here to the Mahabharata's concept of loka sangraha. This really cemented the core philosophy that the usage of the people is superior to all shastras taken together. If a society had organically developed a specific way of doing things, the law bowed to society, not the other way around.
So, let's move on and look at how this builds into practical application with the typology of custom.
We know custom was supreme, but what did that actually look like on the ground? Historically, customs essentially fell into three distinct buckets. First, you have local custom, which is based entirely on geography. A great case law example for your notes is the Collector of Madra versus Muthu Ramalinga, which dealt with specific regional marriage practices, like marrying a cousin. Second, we've got family custom. This dictated things like inheritance, for example, the practice of primogeniture, where the eldest son inherits the entire estate, which was super common among zamindars. And third, caste custom, which governed very specific rituals, like whether an adoption required a formal Homa ritual for Brahmins or just a simple give and take for others, as well as distinct practices for disposing of the dead.
All right, now we hit the core of our explainer. We're entering the modern era, where the law sets up a judicial gauntlet.
This is the critical question for your exams. How exactly does a traditional practice survive today when modern legislatures and courts have totally seized ultimate legal authority? Well, we have to talk about the creep of statutory supremacy. Post-independence, India desperately needed uniformity. The old system of relying on hyperlocal or family customs created a really fragmented legal landscape. Plus, frankly, the legislature needed to step in and reform historical customs that were discriminatory or actively harmful. So to create a uniform legal identity and align the law with modern constitutional values, the state reclaimed its power by enacting the four major acts of 1955 and 1956, the four pillars of codified Hindu law. Because of these statutes, custom no longer has automatic supremacy. It only survives today if it passes a very strict, specific test. You're going to want to take a screenshot of this because this case law matrix is absolutely critical for your exams. A custom today is subjugated to a strict validity test, and you need to aggressively pair every single condition with these specific legal precedents to prove it in court. First up, antiquity. The custom must be from time immemorial, as seen in Ambalika Dasi via Parnadasi, where they traced it back to at least 1773. Second, certainty. It absolutely cannot be vague, which was established in Wilson v. Wilson. Third, reasonableness. It has to be genuine, sensible, and impartial.
In the Raja Varma case, for example, the court ruled that the customary sale of a trustee office was totally repugnant to modern legal values and therefore void. And fourth, public policy. It cannot violate modern law, as highlighted in the Surat Parsi Panchat Dokmas case.
To really see how strict this gauntlet is in practice, let's zoom in on the certainty condition. The case of Ramalakshmi versus Stevenatha perfectly illustrates this. The court was looking at a custom of inheritance and asked, wait, does this custom apply to the absolute eldest son of the father, or does it specifically mean the son of the eldest wife? Because the custom was vague and couldn't be definitively proven one way or the other, it failed the certainty test completely. Make no mistake, if a custom is fuzzy, modern courts will throw it right out.
Furthermore, passing the gauntlet requires proving the custom's operational history. It must have been practiced peacefully, continuously, and without any interruption. And here's a really important one. It must be a compulsory practice. It can't just be a voluntary choice or some nice tradition you do when you feel like it. For instance, under Section 7 of the Hindu Marriage Act, certain customary ceremonies of marriage are legally recognized, but only if they are genuinely treated as a binding, compulsory obligation by the community in question.
Which brings us to our final section, the modern sources hierarchy. Let's look at the new chain of command.
So exactly where does custom fit into the overall structure of Hindu law today? Well, the modern hierarchy has completely flipped the ancient script. Today, legislations, those 4 pillars we discussed earlier, like the Hindu Marriage Act, they sit at the absolute top. They are the primary authoritative sources of law. Following legislation, we have judicial precedents, the binding decisions made by the courts. And finally, when statutes and precedents run out, courts rely on the principles of justice, equity, and good conscience. Notice what's missing from the top of that list? Custom.
I want you to think of custom in modern law as a protected exception rather than a foundational rule. Back then, custom was the primary source of law, often vastly superior to the text itself. Now, the statute is the source, and custom is merely a supplement that survives only if it is proven, certain, reasonable, and perfectly aligned with modern legislation. It is a fascinating journey of legal evolution, going from the living law of the people to the codified law of the state. But it does leave us with an intriguing question as you prep for your exams. Do you think this strict statutory subjugation brought the necessary uniformity we needed? Or has it erased too much of our diverse cultural living law? Something to keep in mind as you study. Thanks for joining me on this explainer, and I'll see you in the next one.